So, today I want to talk about the Supreme Court potentially giving companies the power to sue unions over strikes. It's no secret that labor and union activity has been on the rise within the past year. In fact, there have been well over 316 strike actions in the United States thus far, just this year alone. And that information comes to us from Cornell University School of Industrial and Labor Relations Labor Action Tracker. Now, over this time, we've seen strikes from teachers, from nurses, from Starbucks workers to Amazon workers, and so many more professions. And that's not even counting the actions we've seen from prisoners or the railroad workers denying their presidentially negotiated contract simply because it didn't include exactly what they needed. In short, labor is on the rise, and things are predicted to pick up even more throughout the rest of the year. So, naturally, with labor on the rise in this way, the capitalist class is unhappy. So, it shouldn't be a surprise to anyone that the Supreme Court, with its conservative supermajority, is now setting itself up in a position to take away a significant amount of legal power from unions, especially when strikes are involved. Now, the way they're doing this is that they took on a case as of October 4th that the Supreme Court really should not have agreed to hear in the first place because the case should have been settled by another force, namely the National Labor Relations Board. Now we have here that the case Glacier Northwest Incorporated versus International Brotherhood of Teamsters revolves around a 2017 labor dispute involving unionized drivers at a concrete company in Washington state. Glacier Northwest filed a lawsuit to force the union to compensate it for ready-mix concrete it claims the union destroyed intentionally by declaring a work stoppage. Now we'll get to the details in that in a moment, but moving forward for just now, Washington State Supreme Court ruled that the strike was arguably protected by federal labor law and that the company's claims should therefore be dismissed, leaving the dispute under the Federal National Labor Relations Board. But Glacier Northwest and conservative groups argue that federal labor law should not preempt the company's claims and that it should be able to sue the Teamsters in state court. Now, this is pretty much unheard of, as most cases that are tied to any sort of negotiated labor contracts must go through the National Labor Relations Board. The National Labor Relations Board is usually responsible for dealing with the aftermath of such incidents by figuring out the financial burdens involved. So, in theory, it should have never gone to a state court, let alone been taken by the Supreme Court. And just to back that up, we have this from Reuters on the matter. That sort of labor dispute is a special category of legal action that the National Labor Relations Board has maintained original exclusive jurisdiction over for nearly 65 years. Now, this is from the Supreme Court itself, dating back to 1959. So yeah, this long history that is of legal jurisdiction has been that it has been maintained in the hands of the National Labor Relations Board. And we should understand this for exactly what it has been historically. It has been a governmental compromise to maintain capital by providing some protections to labor, just like in the National Labor Relations Act, in exchange for unions becoming less radical. So if we do indeed see an overturn here, I think it is the unions that need to start looking at their more radical and older options, because the contract that has been designed by the government to keep unions less radical is slowly being breached and broken. Now, when we look a little bit further into this, we see that labor lawyers said a U.S. Supreme Court decision against Teamsters could open unions up to lawsuits by employers seeking to recoup costs associated with strikes, that in turn would make workers more hesitant to go on strike to improve pay and working conditions, thereby weakening unions' most powerful weapon, the ability to withhold labor. Now, Sharon Block, the director of the Labor and Work-Life program at Harvard Law School, had said that she found it hugely troubling that the Supreme Court agreed to hear the case at all after the lower court said that the matter should be left to the NLRB. So what we really have here is that the Supreme Court took this seemingly nothing case that should have just been in the NLRB's hands from 2017 and decided to actively seek it out to review it. which means that they likely intend to make a decision on it that will change the way that the law is currently interpreted. So, further, when we look at all this, we have to understand that they've been actively hostile to labor over the past number of years. So, this leads me to believe that they will likely overturn this decision and make it so that Glacier Northwest was able to sue in its case. And that will change the precedent on how all of this is dealt with. But in order to understand this a little further, let's take a look at what's exactly going on in this particular case. So we have here that in the Glacier Northwest case, Teamsters Local 714 called a strike among its 90 drivers at the company while it was trying to secure a new contract. The strike had begun at 7 a.m. when the shift for the drivers had begun. And they waited to load the machines, the concrete mixing trucks, with concrete while others were already on their way to start making deliveries. Now, according to a Teamsters brief filed with the U.S. Supreme Court, this is exactly how things went down. Now, 16 trucks returned to the yard with undelivered concrete. So there was already concrete mixing in the trucks. And Glacier Northwest claims the union timed its strike specifically to spoil that product, intentionally destroying an employer's property in the course of a labor dispute, as the company put it, since the concrete would be useless once it had hardened. The company disciplined some of the striking workers and filed a lawsuit against the union. But the Teamsters say workers didn't intentionally destroy any concrete. The striking drivers returned the trucks to Glacier's yard and left them running precisely so that the concrete would not harden, the union had said. Now, by doing so, these strikers not only safeguarded the trucks, but they allowed the company to use the concrete as it saw fit. So basically, from what I understand how things went down here, according to these accounts, it seems to me that the union workers had basically returned the concrete to the company, had maintained the trucks by leaving the trucks spinning, and therefore made the concrete available to the company itself to do exactly with what it wanted to. But they just didn't have employees to deal with it. So if they lost any sort of money during all of this, theoretically it should be on the company because they didn't have employees to do anything with it. You can have all of the, concrete in the world, but if you don't have employees to mix it and deliver it, it's not going to go anywhere. So what the company is essentially doing here is claiming that they had a damage to their property because they didn't have workers to take care of the product in that moment and time. Because again, the company itself had access to its concrete, had access to its trucks, and could have done something about it. And they are further insinuating that the Teamsters had basically done this on purpose. So there's two claims really going on there. And the long-term implications of such a case, being overturned by the Supreme Court, could end up making it far more difficult for unions to use strikes as a weapon. And the trouble here is that we really have no idea how far the Supreme Court may be willing to go in this regard. That said, an overturn of this ruling will likely increase the amount of money that unions will need to collect for strikes, simply because they will need to do things like being able to cover additional costs of lawsuits from companies when they happen. Further, if this goes through as predicted, unions may actually have to reimburse employers for any perceived damage during the time of a strike. And that could include things like the workers just having to, leave the job, and any damage or any property that's not sold during that time, as we're seeing in this particular case, could end up being damages that the union is considered responsible for. So essentially, they would be holding employees accountable for not being at their jobs and making striking a less appealing legal option for these workers. In essence, in a worst case scenario here, this could bring about an even worse form of forced labor upon workers, where all strikers are considered to be harming the company and causing property damage. The fact remains that in this particular case, if we look at it through certain lenses, what we're actually seeing here from the company's perspective is that because it did not have employees in the first place to deal with the concrete, that the striking workers had somehow done some sort of harm and damage, which essentially means that workers do not have the ability to in any way, shape, or form go on strike, and their labor is forced as long as they're under any sort of employment. And it's not hard to imagine some sort of alternate example where, say, we were looking at farm workers going on strike near the beginning of a certain crop's harvesting season. And the union of the farm workers were held responsible for the value of unharvested crops. It would be a very similar scenario, except this is how this one particularly played out. Now, I think this is absolutely absurd because the employer shouldn't be guaranteed a right to have employees and labor by the state, and even further be able to mandate fines against the employees and their union if in fact the company doesn't maintain its company well enough to be able to keep employees from striking. And if the company cannot maintain all of its employees like this, and that causes financial burden, it should be on the company's, responsibility. It should be the company's responsibility to make sure that it pays its employees enough, treats them well enough, that they don't walk out. It shouldn't be that the employers are able to use state violence to continue to force employees to work. But that's certainly a possibility we could see from this case in the near future. Now, if you've watched this channel at all, you already know where I stand on the issue of the Supreme Court. It's an authoritarian body of 9 individuals who continue to legislate from the bench in a way that, both historically and presently, makes decisions that lord over our lives and needs to be abolished. This conservative majority leaves us with a situation where our livelihoods are left up to the whims of 6 people who can make arbitrary decisions to protect the financial interests of the wealthiest people on the planet, decisions to continue to destroy the environment, decisions to invade privacy, decisions to control people's bodies, and now something like this where it can revive a court case that should have been left alone a long time ago in order to carry forward its agenda of weakening unions. It keeps legislating further and further and doing more and more harm to more people. And in this one case alone, the justices can absolutely limit union power by forcing them to have to pay back any perceived damage inflicted to a company through the workers striking. And again, that could be something as simple as the perception that the company lost any sort of amount of profit or had any sort of property damage. And if they could convince the courts that it was in some way, shape, or form a purposeful decision by the company, by the union rather, then the company would be able to get all of its money back. That said, all we can do is wait and see what happens for now, but just remember that the current system was the compromise to pull us away from more radical solutions. And they're the ones who are about to break that contract. So we sincerely need to start considering what our more radical and older solutions are, and start to bring them back to the forefront. So with that said, if you've learned something here today, consider liking the video, subscribing, and leaving a comment, as well as consider joining my Discord. If you're in a financial place to do so, and only if you're in a financial place to do so, please do consider supporting me on Patreon, especially as political content like this can often be demonetized on YouTube, and any donations that you provide will go a long way to helping me continue to produce videos like this. The links for everything that I mentioned are in the description down below, and with that said, my name is Anarchist Tara. Thank you so much for watching.